Good afternoon, everyone. Nicole Gardner with Holbrook and Holbrook Law Offices. We are here in the beautiful new office of Remax State in Hamburg. I have a lovely panel here for you guys today. We've got Jenny, we've got Brenda, we've got Jody from Holbrook and Holbrook, Melody, and Tyann. Jody is going to help us through the new LBAR contract. Highlights of good things he's seeing as far as him being an attorney. And then we're going to go through our panel questions. Okay.
Well, I guess we'll start with the new Bluegrass Realtors purchase and sale contract. I know most of you have probably been through either a class or some review of the highlights. I know the old one will kind of be around for a while, I imagine, but at some point, the Bluegrass Realtors will probably remove that, at least make it more difficult to use. I don't think that you'll ever be barred from using it, but in order to stay abreast with everything new, I would get to know this new one as soon as possible. So we'll start with that. Again, thanks to Remax Elite for allowing us to come in and put this on. So the way I like to look at this contract is kind of similar to when we all went from HUDs to CDs back in like 2015. It looks like it's a lot more going on, but they've actually kind of shortened the part that as an agent you're going to be filling out. You're really focusing on the first 2 pages. The rest of it just will be the definitions and the terms that apply to the terms that you filled in on the first couple pages. As far as a review, I'm obviously open to any questions, specific scenarios you may have, but I wanted to kind of give you the highlights from my review of it, just kind of give you some hints, what I think will be helpful tips. We'll all have to kind of see how this all pans out as we go along. Customs kind of drive what we do in this industry, so we'll see how it's used and accepted. But at first review, these are kind of some things that I noticed. Generally, I would say this contract is more seller friendly, more balanced. The kind of the old LBAR contract was more focused on the buyer. The kind of the jokes that you would hear would be, what's the point of EMD if they always get it back anyway? So this contract does do a few things to address some of those concerns from seller side, but it's a pretty balanced buyer and seller. I would be comfortable using it representing either party. First thing I noticed is that they've got a space on there for parcel numbers. This can be very helpful to the title companies because they know exactly what you're going for, but it can be dangerous because if you give them the wrong parcel number, that's what they're going to sell. And if your seller happens to own both the right parcel and the one that you put on the contract, you might sell the wrong piece of property. So just be careful in that regard. You can ask the seller for the tax bill to the property that'll have the parcel number on it. And you obviously can review the PBA website or data, but just make sure if you're going to put that on there, make sure you've really identified, okay, this is the right parcel, because that will be what the title company runs with. Addresses are hit and miss, and some PBAs don't even include them. So be careful with that parcel number. At the end of the day, if you do have a weird one or any questions, or the folks have multiple parcels in the same area, give us a call and we'll be able to walk through what's the right parcel for you, or multiple parcels. Another thing that's kind of identified on here is who's holding the escrow. That is kind of a new blank. It used to just be the buyer's broker. If you leave it blank, this contract defaults to buyer's broker as well. I do see a lot more folks asking the title companies or the settlement agents to hold that escrow, and we're happy to do that. We've got a lot of easy kind of online manners to receive those through a company called Deposit Link and another company called Earnest. And your buyers, if you wanted to have, say they're out of state, mailing a check is going to take longer than the 3 days that the new contract allows to get that. You want to keep everybody up to date, point them at our website. And in that case, they can go through Deposit Link and it'll come right to us, and we'll send you an email letting you know, hey, we received the earnest money.
Is there a fee for that?
The buyer does pay a fee where it's an ACH transaction to Deposit Link. There's no fee from us or you, but the buyer does, I think it's $10 or $12 to process that.
Ernest is 18 now.
Yeah,
Oh, we said 18.
it was, yeah, it's 15, it's gone up to 18.
So, yeah, they do have a few transactional fees there, but it can still be helpful if it's something you're worried about. I have seen a few deals in the past where the buyer's agent gets somebody under contract, they're mailing in the check, and then things fall apart and the check was never received. And then the listing agent's like, so you got the earnest money, right? At least we can fight over that. It's like, well, about that. So this might be a way to kind of mitigate those. You'll also see the buyer's closing costs that the seller is paying listed there and under the purchase price section. That's line 29, which makes it pretty easy to identify. The financing contingencies, which are pretty similar to how they were. This includes an appraisal contingency. They're the main things to think about are going to be your timelines. So there's the new loan application date timeline, which you can set for whatever. If it's left blank, it's going to be a week or 7 days after the effective date.
So I have a question back
Yeah.
here, the contingency. So if I just have somebody who is approved, through like benchmark, would I automatically click financing and then that does financing and appraisal, correct?
Correct. Yeah. If you
Okay.
select the financing, that's going to give you the appraisal contingency as well. Anytime your buyer's doing financing, go ahead and mark that, even if they are pre-approved or the loan's even
Because that
pre-approved.
protects them, right?
Yeah.
Okay,
that'll
what
give
is
them
just
some time.
appraisal then?
So if you're not doing financing and you want to mark just the appraisal contingency, that's going to allow for, there's no
Cash
financing. Yeah, cash buyer to still get that security of having an appraisal done. And that it gives you a little bit of an out. So it's going to go to your inspection period. The appraisal contingency and the title contingency, which is going to be default in everyone. You can't unselect the title contingency with a box on here. But those are good through up until 5 days before closing. So that's going to be your longest kind of, they can still get it out. It's not going to take that long to run a title search, depending on how busy the appraisers are, that can extend out quite a bit. But those are the longest.
Yeah, so if you don't check any, it's cash with no appraisal.
Well, it doesn't have to be cash with no appraisal, but it means you're not going to give your buyer an out based on the financing falling through or the appraisal not.
But if you know they're not going to get an appraisal, what do you do? Which one do you check?
If they're wanting to waive the appraisal,
Cash? with no
then you
appraisal?
would just not check either of those boxes.
Okay.
Yeah.
Okay, cash, no contingency.
Anytime you've got a financing, the appraisal contingency kind of goes in there. If
Right,
you wanted to say, oh, our folks are going to fill that gap, you would just create another addendum to that. The next kind of one of the biggest changes that might jump out to some folks is the inspection clause on this one. I know that in the old form, you kind of got used to option 1, option 2, option 3. This new contract reserves option 1. If you want to waive the inspection, you've got a box there in line 42. By checking that, having the buyer initial off, that's going to be your option 1. And that's no inspection period. You're in at that point.
Could you go back to like loan application day? Because this is where I was really confused on this. So technically our person should be pre-approved prior to showing.
Usually they
So,
will be.
yeah, so on the loan application, do I just pick a date, a random date? Because it says they have 7 days from the effective date of the.
So if your
Contract.
folks are already approved for the loan amount that you put on there, somewhat pre-approved, then they've already applied. So you could just leave that blank and go on.
Okay.
If you want to kind of strengthen your offer to show your seller that you're pre-approved, you could put the contract date in there if you wanted to say they've already met that. They've already applied. Because the loan application date just says that they will apply by that date.
It also said in the inspection period.
The inspection period, it used to be that you'd fill in how many days from the closing day. On this one, you're just going to put the date that you want the inspection period to end. At that point, if you haven't asked for repairs or advised them that your loan fell through or things like that, for any reason other than the appraisal or title, then your buyer is essentially locked in at that point by the end of the inspection period. It's one thing that the new contract does a little better for the seller is it puts that finality on it, because the financing contingency on the old contract kind of just ran until closing. And you've all been in that situation where you're second guessing. So I just got this letter from a lender saying the loan fell through. Well, maybe it did. Maybe they've just got a good friend who's a lender who sent you a letter saying the loan fell through. So this kind of puts an end to some of those games where if they haven't advised you by the inspection period that the loan's fallen through, you can kind of force that issue with the earnest money at that point. So they're locked in.
And Jody, let me go back for that loan application page.
Mhm.
I had a client who was fully approved and, well, I'm going to use the word, he was pre-qualified,
Yeah, right.
pre-approved. And we went and looked, we made an offer on a home. And when he started doing his loan application is when he found out that he was not, and he was young. It was like there was no obvious reason he couldn't get a loan, but he was involved in a class action lawsuit.
Yeah.
And apparently that's questioned. And so, which I didn't know, his loan officer didn't know until he started answering those questions.
So that, if you've got the financing contingency in there, as long as he finds out about that, and it's no longer approved before the end of the inspection period.
As long as it's during, so even if I didn't have that, so well, it's gonna default in
That's
7
just-
days.
Gives him 7 days to apply.
Okay.
The financing contingency,
Is
what
then
they
when-
call the financing termination date, meaning
Okay.
you've got to here, is the
Would be
end of
the
the inspection
inspection.
period.
Okay.
Yeah.
Which
So,
we found out early, but I
Yeah.
reached out to the agent.
so that inspection period date is really gonna drive, like, at the end of
Okay.
this, you need to know whether we're buying this house or not.
So that's the key there. It's not whether I put something in there.
Because after that, the only exceptions you have for a way out is the appraisal short, or there's a title defect.
All right, I got a question on, Zach actually texted to me. How does the second title search impact the closing date?
So what they're probably talking about is the second title search is an update, a title update. So the way the contract is drafted is that title, the first kind of title period has to be completed within 5 days of the closing. The title companies will run, a search right the day of closing to make sure nothing's changed. So if a defect is discovered in that update that wasn't available to be discovered before, that's going to kind of restart the clock and give people new time to correct the title issue if you're the seller. But it really functionally won't change much it'll just give you more days. And if you have said that the closing date time is of the essence on that, it's going to extend that out to give the seller some more time.
So you can extend the closing up to 7 days in this contract.
It can, if for certain reasons, yeah, can be pushed out. Now,
So does it restart the clock or it just gives you that 7 days?
it gives you
There's
that
a
extra 7 days. Yeah. And then it would extend the time for the seller to correct any title defects. So I wouldn't expect that to change to become a regular issue.
So is that okay to still do the blank addendum? To change the date?
The closing date?
Yeah.
To extend it out?
Yeah.
Yeah, you want,
So,
the closing date on this one, if you haven't checked that the closing is, time of closing is of the essence, is gonna kind of be kind of fluid, but the closing date does trigger some other dates. So it'll still be important for you because that 5 days before closing for the title and appraisal, those are gonna key off the date you put in for closing. So even though it's not of the essence and binding on the parties to close by that date, it's still going to set up some other timelines for you. So go ahead, think it through and fill in that closing date for when the parties are shooting for. Because that way it's going to set that appraisal clock for 5 days before that date and set that title defect date to 5 days as well. So you do want to go ahead and fill that in even though it's not binding. And if you have sellers or buyers that you're representing and they want that to be binding, then you're going to have to sign that time is of the essence thing and get all parties to initial that. And that creates a default on the party who didn't close. Where without checking that, it's not technically a default to this closing date.
The inspection period, this is a change, also includes the time to negotiate repairs.
Yeah, it needs to be done all within that inspection period. If it's not agreed to before, then it's essentially waived.
What if the seller's waffling, looking for contractors or whatever to get estimates?
I mean, the parties could agree, but at that point, the buyer, if the seller hasn't come to an agreement, and the buyer has given notice of a problem that they want fixed, then the buyer can terminate the contract.
And most of the time buyers don't want to terminate the contract.
Right.
So I guess that's what I'm saying. What happens if the,
Well, if the parties are still working toward that agreement, they can still come to an agreement.
Addendum to extend the inspection period is what I usually do in that case.
Yeah.
If I know I'm up against a deadline, then I write an addendum and say buyers and sellers agree to extend the inspection period to 11/49 on this date. And just have everybody sign an addendum.
Yeah, that would work.
Just like in the
That
old
would work
contract.
too. Otherwise, if you don't have that extension, your buyers are playing with house money at that
Right.
time. They can kind of say, well, we didn't make the agreement, we're out. They get their money back. Because they gave notice before the end of the inspection period. Yeah, the dates are gonna be important on this one.
I know you're probably getting to this next, the deed, can you remind me, like, what's the difference, when I'm explaining to a first home buyer, what's the
Sure.
difference between a general warranty deed and a special warranty deed?
Yeah, we get this question a lot. So Kentucky, you've kind of got three versions of warranties that a seller can give to a buyer. The general warranty deed is a promise that the property is mine and that there's no problems, no encumbrances, it's free and clear to you from all time. Like my prior owners don't have a mortgage on it, they don't have any liens that will affect it. I'm promising you, you're in great shape. On this, the general warranty deed is the default. It's what you typically see at an arm's length transaction. Most sellers don't have a problem giving a general warranty deed at closing. The special warranty deed is kind of a slight tweak on that, where I'm not, as seller, I'm not promising you that it's perfect. I'm just promising you I don't have any problems. I didn't encumber the property while I owned it. And if I did, I'm paying it off at closing. I don't have any liens on me, but if the prior owners, they have some issues, I'm not promising anything about that. So you're taking this from me, subject to any prior owner interests. You see that with the VA, if they're selling a foreclosed property, they're not going to give you a general warranty deed. Banks typically prefer a special warranty deed. Some estate attorneys will do a special warranty deed, but those are kind of few and far between. The third example is a quit claim deed that you've heard. Usually you see those interpersonal family transfers. And what that means is I don't make any promises as to the property, but whatever I own, you get. So I'm quit claiming my interest to you. If somebody else has some interest, you can't come back at me for it. I'm just saying that anything that I have is now yours. And you see that with husband, wife, me to my own company and LLC. Those are kind of your typical quit claim deeds. And that's just kind of a no promise, whatever's mine is now yours, but I'm not promising I have anything. And those are your three kind of versions. If you have a seller who wants to quit claim deed the property to your buyer, that would give me pause. Why? It doesn't necessarily mean a deal breaker, but you see that with the VA usually. On a VA foreclosure, when the VA takes title, they will quit claim it to the new buyer. And typically I advise folks that that's fine. You're going to get an owner's title insurance policy anyway. Go ahead and do that. And really you don't have to worry about it. And that's kind of the answer to most of those warranty issues, because even if you have to go against a seller based on their general warranty deed and some prior owner issue comes up, you can't, what's the saying? You can't get blood from a turnip, right? So if your seller is judgment proof and doesn't have a stack of cash they're just going to pay you with, you're stuck anyway without the insurance policy. So if you have a client who's been offered a special warranty deed, they're concerned about it, you can say, well, you were planning on getting that owner's title insurance policy anyway, you're covered at that. So that's the solution there.
Would short sale fall into that too?
Well, a short sale is gonna probably still be a general warranty deed. From the title perspective, it's really no different. The only difference on a short sale is that the current lender is not getting all of their money. So that wouldn't really change the transfer because you're still going from the seller to the buyer. If on a foreclosure, then you're getting from a bank to a buyer or from the master commissioner sale. Those would be special warranty deeds. Yeah, the deed question is a good question. I'm glad you brought it up. Those do come up from time to time, and buyers are sometimes nervous about taking less than a general warranty deed. And I would just advise them to get the insurance policy and let's not make that a deal breaker. The time above the essence, we kind of hit that. If you want the closing date to be binding on everyone, make sure you get that checked in initial. The next section there is the addendum. So if you are including an escalation clause or something of that nature that's not included here, that's where you'll put your addendums and make sure you attach those. The expiration of the contract, so that's just the timeline for the buyer or the seller in most cases to accept. That was the same thing that you're used to on all the old contracts. Actions that we were kind of getting into, the difference now is they've combined option 2 and 3 into one. And I think some of that we were already seeing throughout the crazy market we had 2020, 2021. Everything kind of became option 2 because it's, the sellers had more power. And option 3 has always kind of been option 2 if you think about it. Because if we don't agree, we're back to option 2 and we don't have closing. So this kind of does away with those distinctions that really functionally didn't have a difference. So, option 2 was we want to ask for repairs, but they still could. I mean, yes, they can still say, well, we're not going to buy it based on option 2 unless you do this. So you're really in the same place where option 3 became, we're locked in as long as you do what we ask. But if you stack that list up based on the inspection report, no seller's going to go for that. So you're right back where you started. So I don't think this is as much of a change as it might appear. Now you've just got, do you want inspections or not? And I think that's generally the question we were always asking before. The one interesting part of this that I did notice was not only the timeline that we've gone through, you got to ask for those repairs in writing before the end of the inspection period, but that the seller is responsible for re-inspections if the inspector couldn't get to something. So it's kind of a one-off little line through there, but because of that, to avoid some problems on this, I would probably ask your seller to attend the property inspection. That way they're there, the home inspector can say, I can't get to this. You can go ahead and have them move whatever's in the way, do whatever needs to be done that way. So your seller's not on the hook for another inspection. If the buyer gets the report, it's like, well, I wanted to look at this, but I couldn't get to it. According to the contract, the buyer could say, well, seller, you're paying for the next trip out to the property. So you may want to have either the listing agent, if you're the listing agent, show up for that inspection.
I thought we were told not to attend.
Inspectors usually do not want
Yeah,
sellers there,
typically they don't want you,
but they have no right to say you can't be.
but it is still your house.
I thought that even
From the agent.
from
Yeah.
the agent's perspective, I thought we were told not to do that.
Jeremy has
because-
always had the position of,
Yes.
agents don't need to be inspectors or
Because
need
you
to
put
know.
yourself in a liable
Yeah,
position.
Well, you don't want to be doing the inspection. But you
No,
might
but
want to
if
be
you
on
attend
standby.
it, otherwise, even if the seller attends, if he hears something and he's got to disclose it.
Yeah, maybe not
So-
follow the guy, just be available, so that if the and then maybe ask when the inspector comes out of the house, was there anywhere that you didn't get to go, that you want to go? Just so that you're there, or maybe you could be on the phone with the inspector after the fact and say, let me just make sure before you leave that you've covered that.
You can even call them ahead of
As a
time and say, if
listing.
you can't get to something.
Right.
Let me
call
know, I'll
and
come back.
Call me and I'll fix
I
it
just-
while you're there.
that was kind of an interesting statement that's in there, and I just wanted to make everyone aware of it, that
Well, it's been an issue in the past where the inspector couldn't get to something and the buyer has to pay for a re-inspection, but it's not their fault.
Yeah, but we
Right.
have one inspector that a lot of you all use. He didn't even go up on the roof. He didn't even inspect the roof. He didn't even go into crawl spaces. He's a big boy and he doesn't do that. But a lot of y'all use him. So are you all for that? I mean, I'm just saying.
Who do you
I
mean by
never
you
used
all?
him. I would use him, but
Are you gonna drop
Who are you
names?
talking?
no.
After we're off
Being
dating,
recorded.
No.
Yeah, you said you all, like I used.
No, but
someone.
I do know that several people in our office use him very, and
Mine's-
he has a thing in our office occasionally to, pamphlets and stuff. I don't use them. I would never recommend, what I'm talking about. I mean, I guess because I'm like a rule follower and
I
always
have no idea what she's talking
terrified
about.
that I'm gonna get in trouble, that.
Sure.
That I would never use somebody who, or recommend him. One, his prices are much cheaper, so I think that's one of the reasons why people recommend him, but he does not do valid job for people.
guys, I'm getting cute. Do we have a break where we can say why it's important to use Holbrook and Holbrook or another title company that is of good reputation and an example of maybe a terrible experience versus what you receive with us?
I've always recommended Holbrook and Holbrook actually from the beginning of my career.
Yes.
And I've always had
Yeah.
one of her phone calls. And when I was a new nervous agent and took care of me, like always had time for every phone call. And you've been in the situation at Holbrook where they have caught something that was missed on the previous one and also by a reputable title company.
Yeah.
And it just made me know how thorough it is. And everything is just always on point for me when I use you all. It's just, I'm always coming in with some crazy, I've got this client. And I'm like, here I am again. Oh gosh, they're gonna throw me out next time. But I've always been treated, and my clients, and that's important.
Yes.
And I get a lot of compliments from my clients on Holbrook and Holbrook.
Wonderful.
So,
Thank you.
Appreciate that.
I always
Yeah,
feel
That's awesome. Yes,
Yeah.
that's what we want.
And I would say that Jody has always been very responsive and Nicole as well. Whenever I've had title questions or issues with any of my clients, when I've reached out to them, you all have been very responsive. And I appreciate that because then my clients feel like you've taken care of them.
Well, thank you.
Through me, through my association.
I think for
That's
me, nobody ever really explained things to me when I started real estate on what you do with a contract when you have a buyer. That you kind of wait for the lender to reach out to you. That's not really how you do it. As soon as I get a signed contract, I send it on to Paige and CC Nicole automatically to get the ball rolling. So for me, nobody explained that that's what you kind of need to do. Don't wait on anybody, you just do it. And that's, I worked my first year, Nicole and I were on speed dial. I had my client die. He had to be out of, his wife came home, had to be out of the house. She had a funeral on Saturday, had to be out of the house on Monday. And they helped me through that. I mean, it was weird. And thought he was helping her and he did a quick claim deed and he made more issues and they walked me through it, helped me out, helped my client. And since then I've been super dedicated. Jody's helped me out with stuff. I had somebody trying to buy a contract that was my father-in-law's house. I mean, it was just, they helped me legally, professionally, just everything. I want somebody who's going to be there for me.
I think what Brenda is emphasizing there is when she gets a contract, she sends it to us and the lender and says, hey, lender, well, not yours in particular, but you could say, hey, lender.
No, I always do. I want them to start
We're going to
everything
use
start.
Holbrook and Holbrook. That way you are in control of the transaction.
I do that too. I send it to you first, sometimes before I send it to the lender. And then I write the lender, we're using Holbrook and Holbrook, and I've already sent it to them.
Yes. Yeah. Like it.
And I use Holbrook because I was trained under Brenda. And Brenda
And had no
said,
other options. No,
and
just
Brenda
joking.
said, you use Holbrook and Holbrook. And I said, if it's good enough for Brenda, it's good enough for me. But since then, I had the buyer on a house that had a horrendous title. The owner had changed names 3 times and a whole bunch of people had died and it was given to them instead of money from the estate. And so that attorney who was working on that one, I did not choose them, refused to proceed until they were paid for their extra service. So it held up us finishing. And it got nasty between some members of our brokerage and that attorney.
So.
Yeah, thank you all. I appreciate that. But I do
Is that
think
Jody?
that the importance there, whether it's Holbrook and Holbrook or or anyone, is building that team and that relationship and knowing what to expect. Because what your clients are looking to you from is looking to you for is consistency and knowledge, knowing what comes next. And if you aren't used to working with that group, you're going to tell them, I don't know, just wait and see what happens. Where if you've got that team built with the lender you like to refer people to and the title company you like to refer people to, then you're going to know what's coming. And there's no better peace of mind for that first time home buyer than, well, Brenda said we're going to get this email on this day. There it comes. So she knows what she's talking about. As opposed to, well, we'll see how they do it. That's a much less comforting, I think, conversation to have with that client. So hopefully it's us, but if not, definitely establish those relationships and stick with them, because you can get a lot more. And then if you do have that problem, you've built the relationships with the folks there, and they're like, hey, this is a client of ours. This isn't one deal. This is a years-long relationship that I'm going to bend over backwards to make sure this works out for Tyann and Brenda and Jenny. Melody, you're going to make sure that you meet those based on the relationships. So
The other thing, Jody, is that I can go online anytime and see where my closing's at, what all.
Oh, she loves that, yeah.
yeah,
Yeah, I love that because I hate having to call and then you get voicemail, at another company. I go there, check first, and if I'm not seeing what I need, then I call.
Yeah.
I mean,
you can check.
I do
do
like
have
that
a
you all like,
question.
you have our back. So for me, I have a corporate client and I have no way to prove their cash. No way, you know what I'm talking about?
Yeah.
And I have to give Nicole's number, or Jody's and say, you're welcome to contact one of them because it's a corporation. You can't give money like that.
So I verify funds that
Yes,
we've had no problems. in the
Yeah, I mean, I
past, yeah.
couldn't have anybody else verify because we're their corporation. So they do take.
I have a question about, I've run into it, I think just one, maybe twice, where a lender refuses to accept. I thought by law, it's the buyer gets to choose. That's what I learned. The buyer gets to choose who does deed and title work. But I have had lenders say, well, they're not in network or whatever it is they call. And they absolutely refuse to use the deed and title of our choice. What can we do about that? Because how can they force us to?
It's like Central Bank.
Central Bank was the one, and they were so adamant because I said, look, they've already started this. I already sent it to them, and I said, we absolutely refuse anybody else, and they made us use their in-house title. That seems like even a conflict of interest.
Well, they, not necessarily Central. I don't think they own any part of Mary, but there are companies like Chase that use National Title Company. They do own the title company.
Sure.
Yeah.
You can push that, you can push their buttons, but at that point, I don't know that I would, because I don't know it's going to get you that far and it's going to tick them off.
Yeah.
Yeah,
Some of them have those financial interests. Then the way the law, as far as the buyer gets to choose.
Yeah.
So they can't be forced to accept an insurance policy from somebody that they don't want to.
Okay.
But as far as deed work closing, there's no protection there.
Okay.
The buyer could say, well, I'll use a different lender. Of course, they're not being forced to,
No, they're not.
but you don't want to, that's going to frustrate your transaction more than it's probably worth. Kind of grin and bear it on those, but
and if you have any questions,
Yeah,
even if it's
we're
not
still
our
here.
deal,
We're not
we're
involved.
here for you guys. We'll
Yes.
answer any questions. It's not a problem.
Okay.
My daughter bought a home through Central Bank and they barely let us do the title work. Now, how about that?
and it's just I think they're probably not acknowledging the benefits of having a long-term relationship.
Yeah.
They are taking over the situation in a way that I'm encouraging all of you to do. I think that's a smart move. Keep it-
Do you know
keep
I've
it
showed up
in-house.
at the wrong location twice for a Central Bank? Because-
Really?
Yeah.
Nobody-
You were there with me once.
Nobody tells you.
They
We send out those nice closing.
I love those,
Hey,
yes.
yeah.
It's the happy day email.
Yes.
Yeah.
Happy day.
Because she has an office in the Chase building next door.
Yeah.
And then sometimes, depending on who it is, it'll be at the Central Bank building.
Well, and one more plug, like I had a closing that involved an international buyer. I represented the seller, but the buyer's agent reached out to me and said, do you know any closing office that would have someone that speaks Spanish? And so I recommended Holbrook and it got closed up in Louisville.
And we're gonna
It's
have
great.
more and more of that, guys. So that is a niche
It's great.
thing that we.
So it really stepped in and did a video closing with the person that was in, South America.
Oh, wow.
Yeah, and witnessed her signing her documents and then closed the next day here.
That's fantastic.
So it works
That's
really beautifully.
Kentucky since 2020 has
Right.
allowed what you're talking about as a remote online notarization. And we kind of jumped on it. So I think in March of 2020, after that first came out, there was a client that I think it was a COVID situation, maybe that got COVID. It's like patient 0 in Scott County, I think, and couldn't make it to their closing. And we recorded a remote online notarization deed in Scott County.
That's right.
And I hadn't heard of any other ones yet, neither had the Scott County clerk. So when we sent it in, they gave us a call like, what is this?
Well, you can't do this.
And we kind of worked through the statute and the effective date. It was like, okay, we'll record it. So we've been doing a lot of those. It's very convenient. Now, usually if there's a lender involved, that's only going to be available for the sellers. Some lenders aren't comfortable with that way of executing documents yet. Cash deals are wide open, but the seller side is also. So if you got sellers that can't do that, we're seeing more lenders that will allow it and some even facilitate it. So it's coming. But
Yeah, I
It's a
think it's
great
gonna be.
experience.
we want to be out front. So
Hey, Tyan,
it's pretty neat.
Yes.
how were you able to explain the new contract to your sellers? And did they raise any concerns about the contract?
So my seller did not. I just got an offer Friday night that was on the new contract. And it actually, I sent her and I told her that, this is a new contract form. This is the first time I've had someone make an offer on it. And so I've always done bullet points when I send emails to my clients with any offer I get. And so I just used bullet points to kind of explain the flow of the contract so that she would understand it. And she's very thorough. So I sent the contract so she could read it as well and see and understand. And it was pretty straightforward. It wasn't, it was contingent on the sale of a home. And they did ask for a long inspection period. So we were set to close on or before March 3rd. And the inspection period ran through February 24th to close on their other home on February 28th. So there were these different dates. But when the bottom line came that it was contingent, I was talking to Melanie, contingent on the sale of the home, or they would get earnest money back, it really defeated the inspection period. Because I was like, well, I might want to shorten this inspection period, but it was a moot point. So we kept it as it was written. I didn't make any changes, but that was what I was thinking is how do I protect my seller in some of these situations? And it was so straightforward and it made so much sense and it's working out great. So, but I did, just go through the terms and give explanations like here's the purchase price, here's the earnest money, here's the closing date. This is the way the inspection works. I didn't go into that 1, 2, 3. It was here's your inspection of
Yeah.
everything.
Yeah.
And we have to have it negotiated by midnight this
On,
day.
yeah.
So it's the beautiful thing is it's very straightforward,
I think so.
which I liked. So
I like it. It's very, it removes a lot of doubt,
It does.
especially the inspection period.
exactly. So that's, I didn't have any issues. So from February 28th
Yay.
Congratulations.
with a new contract.
There aren't functionally a lot of other changes in the new contract. A couple, the closing costs are still customary. Buyers are paying for the title insurance, lender fees. Sellers are doing deed prep, transfer tax, seller closing fee, that kind of thing.
It does make you talk about the title insurance before.
The owner's policy.
Yeah, there's a little
That's what
blurb
we
in there.
talked
It's still
about.
optional. Obviously, I recommend everybody get a policy, but I see a lot more title problems than most people, so probably like the firefighter with 15, smoke detectors in his house. Still, I recommend it. I see it saved a lot of people from some crazy situations.
Yeah, I like to say the attorney recommends it.
Yeah,
That's my recommendation.
well, you've got the most rapport with your client, and you're gonna be the first call when they go to
Right.
refinance if there's a problem. So I would at least, if I had a client that was like, I don't want that, I'm waiving it, I would include in some paperwork that
Sign
yeah, we
something.
talked about it.
Yeah.
It was
It's just
recommended.
scary when it happens
So-
because it's at closing.
Yeah.
The people are already giving their, money, you're asking for more money. And it's like, you have 30 days.
But
Yeah,
the argument is that, this is your greatest investment. And if you're buying a $400,000 house and you're talking about $350, it's a very small payment for a large investment. And so I just say it's the greatest way to protect yourself for
Sure.
any type of question.
But But I do agree, timing of it, I think is the issue.
Yeah, the timing of it showing up at closing when they're
Closing.
already,
Well, you
they're
know,
already in
it's-
mode, they're already
You
stressed.
know, it's interesting, it's in Louisville, it's an out, not opt-in, and lenders go ahead and they
It's
I would say
included.
98% of, yes, it's included in their, in their closing costs, so it's already taken
And they're
care
just
of.
should be
saying,
that way
why don't they
now.
do an
Yes,
opt,
it
why don't they do it that
was,
way here
yeah.
where it's an opt-out, not an opt-in? Because like, I said, it's like any insurance. If you don't need it, it's great, but when you do, you better have it.
Really
Yeah, you're
want it,
losing
yes.
everything. It's like, like homeowners insurance or anything. You can lose your whole home to fire or whatever, you know. You may not burn, but if you do, you've lost everything.
I think agents could educate their borrowers on when they're talking to their lender, hey, could you please price out the owner's title in my total closing costs?
Okay.
Yeah.
And then it's just the one number.
Yeah, and it's not, the number's not changing and I have to spend all my money and I need to buy a couch or whatever.
Yeah, it's easier from the front end.
Yes.
Why is it so different in Louisville? What's different there than different
Oh,
here?
they had a big,
It's just
tell 'em about it.
customary. So
No, they
there,
had a situation there
yeah,
that.
there have been
Huh,
major claims over the years.
a whole
and
neighborhood.
It was big
Because-
enough that they've kind of adjusted their contract
Okay,
to say an owner's title insurance.
so there was a
policy.
situation where,
It was so,
It's like a subdivision where the heirs came forward after the houses had been built.
There was
and
an
a
illegitimate
missing heir, so to speak.
there was a missing heir and he was
and
owed
the will was, said, I leave my property to all my heirs.
heirs,
Dad passed first, mom passed second, dad had a ill
Right.
son.
illegitimate son. yeah.
Yes, and he proved it and I was
Outside of
trying to be,
marriage.
I didn't know what.
Well, outside of marriage, whatever, he had a son, yeah.
Yes,
But
so,
nobody knew.
and he
Yeah.
proved it, and so he owned a part of every one of those $350,000 houses. They could, it was unmarketable.
Oh, yeah.
So that, experiences like that make
I mean, you
people,
don't expect it.
No, nobody thought about that. So, yeah, Louisville, they're like, oh, yeah, you're getting it.
That's crazy. So how do they resolve that?
Unless you had title insurance, you had to negotiate with that
Yeah.
man,
With that individual.
because he owned part of your house.
Out of your pocket.
Yeah. Attorney's fees, the whole 9 yards.
We'd be
Yeah.
on 911 too.
yeah.
Yeah.
It was,
Tony!
it was definitely a problem, and that kind of scared straight the whole market.
The whole market, yeah, that would scare you straight, yeah.
Yes.
That's
Well,
what-
because it was a whole subdivision.
For the title section in the contract.
Yeah.
Can you just like give me like a synopsis, like going line by line, just because if I'm gonna talk through this whole contract with my buyer, I
Sure.
just wanna kind of break it down.
So if you're talking with your buyer, you're gonna say the seller has to present marketable and insurable title. If you're worried about that, then we can have a conversation about the insurance that's available to protect you. If you're not, just know that before 5 days of our closing date, you're gonna know if there are any defects that you need to make the seller aware of. If anything shows up, like, hey, seller, you may not have known this, but the person who owned it before you had XYZ issues and the title company is telling me those need to be resolved. You just want to make sure in writing that your seller is notified of that, because that puts them on notice, starts the clock so that you don't hit that 5-day mark where you can't tell them anymore. Now, that's something that, we're going to do on your behalf. If there's a title
That's
issue,
what I was gonna,
we're going to go straight to the listing agent. I assume that would be standard practice for anybody, but
unless they're understaffed, so.
I would
And
say,
they don't find it until 2 days before, what do you do then?
Yeah.
well,
Oh, there's
that's,
a lien.
that's
So
a
if you're a
problem.
seller's agent, it's good to go ahead and quickly get with the title company they choose to go ahead and start that process if it's not.
Yes, send in your seller's off, well, have your seller sign it, sellers early and quick and often rather.
Yeah.
We want your information, seller's authorization, so we can go ahead and we run title. Once we get the order, it's set up for title to be run. As soon as title comes back, our typist types it up, we send out an email, and if there's something unusual, anything outside of a first and second lien, meaning a mortgage and maybe a line of credit, we'll say in big red letters to the lender, hey, Mr. Lender, we're working on this, but this could be a potential problem. That way, if you need to set expectations with your clients, you can do so at that time. Because it takes some time for an unreleased prior mortgage to be, taken care of, or a lien, whatever it may be.
Which is my very first deal.
Some crazy stuff.
happens.
We had a crazy one last week. Week before last, we had a neighbors swapped a little piece of property. And they thought it was no big deal. And a real estate attorney actually did deeds on it, but he forgot to ask if there were mortgages on there. So there were mortgages on there. And when they swapped the property, the mortgages weren't released. Big old mess.
Oh.
Jody figured it out though.
We got that.
So she said she has the seller,
I'm just
and
thinking,
you're saying have the seller
You know, the
The
document.
start,
says
go
on
ahead and
the
start.
mortgage,
Well, there's
their last
it's
certificate,
payoff.
4 digits of the.
Oh, the
certificate.
payoff. Oh, yeah,
But you
yeah.
have to be in,
Okay.
and you basically have to be in communication with the buyer's agent
Mhm.
on which title company you're in.
Well, as soon as we get it.
We send out
it
agent sheets.
Yeah.
Yeah, that's
So
our
you'll
process.
know,
Yeah.
Right.
you know, it's the same thing.
well, you guys are fantastic though. We're talking about like little podunk attorneys that are, you have to like.
You have to
track
wrangle them.
down.
Yeah, wrangle
And
them.
so just, it's,
As a seller, if you've not been put on notice that there's a problem, you don't need to do anything. Because this is on the buyer to within 5 days before closing, let the seller know if there's an issue that they have to fix. Now, like I said, the closing agent, if there's an issue, is gonna be telling the seller, hey, you've got a problem. So they're gonna be on notice if it's with us. I would assume that's the case anywhere, but as the buyer, if you are made aware of a title issue, shoot a text to the listing agent. A text in this contract is considered written notice. That's true of the inspection period. It's true of, anything. I thought that was pretty interesting that they've included text, which makes sense. That's what we do.
That's what we do
these
now.
days. So, FaceTime would not qualify, so it has to be written, but yeah, email, text, letter, any of those would qualify as long as they're received within that period. Thing that this contract continues is the mediation. You got to mediate. Parties split the cost of that mediation in this, and mediators can go $300 an hour type of thing. So,
What do people need to mean? What do you need to? Repairs?
Usually it would be there's dispute on who gets the earnest money. We've all agreed we're
Oh,
not
okay, so
closing.
that's just a broken-
Yeah, it's always,
Yeah.
it's always money.
Yeah.
Always
Money.
money.
And then at the end of the day, it's like, well, who gets this $5,000 in earnest money? Did you default? Did I default? Then the contract is written in that everybody agrees before we start suing each other. We'll go talk to a mediator who's going to listen to it and give us like, here's an equitable division of the situation. Or you're in default. It's going to at least let everybody know where they likely stand should it go to trial. I go back and forth on them. I think the reason it's there is to prevent the constant threat of litigation, because without that mediation clause, even with the mediation clause, you still hear people, well, I'm just going to sue, or I'm suing, or I'm calling my attorney. It's like, it's fine.
How many times do
But
we hear that?
If you actually sue them, the judge is going to say, what was the result of the mediation? Oh, y'all didn't do it. This case is on hold until you do that, because you're suing them over a contract that requires it. So mediation
We
clause
never
is still
tell
there.
our clients though, or tell somebody or the other agent, especially that we are gonna sue them. That's really.
Well, not if you're actually going to sue them, but if you want to.
She likes the surprise factor.
Nobody had a
No,
poker
I
tape
just
that
remember
says,
one of
"Wait,
our
you see
agents
me."
got in trouble
Yeah.
for that.
Because she said, we will sue. You can't say we, you can say my client, because you're
She
not
did
part of the
say
lawsuit.
that.
Yeah. That's what I'm saying. You should never you should never put yourself in the same boat as your client. You represent your client. You are not you're not doing, you're not part of your client's process.
It was.
It's never a we, it's always my client feels, or my client thinks, or my buyer, my seller, they're gonna do
You
this.
know what-
I'm just the informant. I'm the
I
messenger.
think that's how it went down.
Yeah.
It was 3 days before.
We will sue.
Yes, and literally the people had already moved to Nashville, I think, and the buyers wanted to back out. And the agent said, you can't back out, we'll sue you. And
Because she said we. That one little word,
One little word's bad.
instead of my
Bad
client or
word.
my seller.
Yeah.
So, go to mediation if you have.
I don't know if she said will or they'll sue you. I don't know. But she major trouble. She almost lost her license.
The rest of it is pretty similar.
Awesome.
I have a question real quick on inspections
Yeah.
for the termite.
Oh,
So,
yeah.
can we just write residents only and have them initial?
Oh,
Is that
yeah,
good
it
enough?
does
You
say
know what I'm talking about? Remember I had to
pest
say-
inspection covers all improvements.
You don't need
So
a, yeah,
that
there's
would be the garden shed. That would be, you know, things that,
five barns on a. piece
bunch of
property.
barns, which,
The playhouse.
Termite. I've had it
Yes.
twice.
yeah.
A big playhouse in the backyard,
Yeah.
But if you've got why would you want to say?
Well, I'm talking about if you have a house, you know, 4-bedroom,
Yeah.
3 and bath house, 2-car garage. And, or if you have a barn, like whatever, you know, a barn's gonna have termites no matter what.
But if you've got
But
the
you don't wanna
buyer.
treat them.
You want to-
no.
you want to-
When the buyer, you want
If
that inspection.
you're a seller,
If you're a seller, you don't want it.
Yeah, you don't, you're talking about a lot of money if you have a lot of, like, okay, where you live, how many things you gonna have treated? And I guarantee you have a, or a, you know, a garage, a barn, yeah, so you have, can you say on there residents only?
I
And
mean,
just
that
have
would be an
everybody
addendum.
initial?
Yeah,
Oh, you
I
can't
wouldn't
just-
mark through it.
No, not mark through it, but just put like residents only.
It
It
says
says
not
all,
to
it says
Yeah.
all improvements, all
What page are
improvements
you on?
located on the property.
The bottom of
Page
page
4,
4, yeah.
Which I think our old
Barn's got a-
contract said that,
Yeah.
because I went back, not sure if the detached garage was included
It is.
as being a requirement, and it does
think
say
that's
all
changed.
Oh, it
improvements.
says
All
all
improvements.
And
buildings,
so that's when we went back and
Well,
said,
some
so,
loans, I mean, like a VA loan, you absolutely have to get that
Correct.
back.
Yeah, the
You can't
FHA I
skip
did.
it. You have to send it back out, they skipped it.
No, I thought that they did away with the pest inspection from the VA being mandatory now.
It,
It
the
is-
seller, it's not mandatory for the seller to pay it.
That's what it
It's
is.
still
It's still mandatory for them to get it, but
They
it's not
took,
mandatory.
they took away the mandatory for us to have to, the sellers have to pay.
Pay
for
it,
the
yeah.
VA.
okay.
But they still have to get
The
it.
loan itself still.
Still has to
Yeah.
have it. But yeah, that very last line just says, it shall clearly indicate that all improvements
Yeah.
located on the property were inspected. So if you have a detached garage or a detached building of any kind. it's
Right.
it, you know, it's-
I just think if you have like a farm, several outbuildings.
But those typically don't go under VA loan or go under FHA loan. Those are
But that's
typically
not-
conventional loan.
That doesn't
Yeah.
have anything to do with the,
Yeah.
in here it says all outbuildings.
Well, what she
all
was saying
buildings.
was some loan types require you, no matter what you
Yeah.
put in there, they're gonna require the buyer to do it. But you could put in your addendum clause that only the residents and no outbuildings.
Do you think you're gonna see a lot more addendums?
You might, yeah.
Yeah, because they said they don't want us to modify this, put it in addendum, everything was put in addendum.
I mean, that's what it's requesting here is that any additional
Yeah.
changes will be
So
made.
this fraud warning too here, okay, so I have a client that's currently in DC, I think, and she's just gonna buy something sight unseen or whatever with, but her family's here. so
Sure,
She's gonna do probably, you know, cause cash, she's just gonna wire it
funds,
to you all.
sure.
So how it, I don't, do I decide that?
So
Do the
any,
addendum, even like the
I
escrow?
wouldn't add it at all to the contract. That's
Could I
just-
do it on the addendum, that the escrow will be wired to you and the,
I would just fill in that Holbrook will be the escrow holder. And as
okay,
long as we receive it within that 3 days, you're in compliance. So you can just put H&H in that form on page, I think it's 2. Let's see, no, page 1.
Okay, speaking of fraud, I had a friend that this nearly happened to. Because they got something and they were getting ready to wire the money and they went through and checked and they were like, something doesn't look right here.
Sure.
Jerry Larson. And so it was caught. But what does Holbrook do to make sure the wire fraud doesn't happen? It's like I've got an elderly client going to wire
Sure.
money at the
So
end of the
the
year.
only way you
There's
can
other in the month.
really mitigate fraud is to get out in front of it. Get your people educated early that this is possible. What we do as part of ours is the information sheets that go out to the buyers, they have to check. I've read the wire fraud policy saying that they will call our office to verify. And that's really the way you stop it, is before you send it, stop, call using a trusted number, not a number in the email that sends you the instructions. But get online, find a phone number that's posted and call and say, I need to verify this.
whose number do we give them on this situation, like, that you'll hold the escrow and the,
Office and mine, I mean, it doesn't really matter, but if they're just gonna send us earnest money deposit, they can
Go online.
go online and do it, or bring a check to the office, whatever's convenient for them, mail a check to the office, however they want to do it. But yeah, the fraud warnings, the best way is just tell them up front. And the way I would say that is, I'm never gonna send you wiring instructions. If you get wiring instructions that look like they're from me, call me. Don't send money. And it's right up front. And that's gonna be your way of doing your due diligence to make sure that they're not later saying, well, Brenda told me to send the money here. And you're like, I didn't.
Because the agent always wants to be removed from that.
Keep yourself out of that. But the only way to get ahead of it is when you first meet them, I'm never gonna ask you to send me.
Right.
Should be what you're telling all your clients.
And work with the title company we have a two-tier process that
Sure.
we're making sure that those are in fact the accurate wiring instructions coming from the right person. And we call.
Yeah,
A lot of
when we're
companies,
sending them,
yeah.
like on the seller side, we have to fill out, sign a form for that, and then we call the bank and make sure this is still going to the right account.
Yeah.
So we're doing the same, we're jumping through all the hoops that we ask the buyers to jump through for sure. But yeah, the best advice to you guys would be, I'm not gonna ask you to do that. If you get anything that even looks like it's for me asking you to send money, don't send it and call me. And then we'll figure out what's going on. Because for the buyers, that's the dangerous thing is
Yeah.
nobody's talked to them about it. And they get an email that looks like it's coming from you. And they just do it. So if you haven't had that conversation, they may not know, but I would have that day one. And we'll handle the seller side. Obviously, we're sending that, so we'll be able to control that gets to the right spot.
You did probably answer this already. I have one more question about title insurance.
Mhm.
It covers all three, right? It covers general, special, and quitclaim deed.
Yes, so if we're able to issue a policy on a transaction, it wouldn't matter how it was.
It wouldn't matter if it was quitclaim deed or okay. I didn't know if one was
Because we're
more
insuring,
risk.
we're insuring the buyer.
Mhm.
So if we have insured that property, then we have based it on the way the buyer owns it.
Okay.
We've done our search that's required for the insurance underwriter, and then, the insurance underwriter is standing behind that regardless.
Okay.
Yeah, we've had some interesting owner's title claims recently.
Hours, so is there anything, we'll get maybe one more thing and then wrap it up?
One more thing on HOAs on here.
Sure.
What do we need to do? Anything in particular?
Nothing new. I would just make sure that your sellers know, that's gonna be the standard. Sellers have to pay any assessments that are currently due, and then the buyers pay any that arise after the closing, which is
Andover's
kinda
doing
standard.
that, right?
Andover is the
$1,000.
one
Yeah.
interesting one. So
Yes.
technically, based on the contract, all those green space buyouts in
Uh-huh.
Andover are the responsibility of the seller.
Unless it's on the seller's disclosure.
Well, even then, the seller would be responsible for paying it on here unless you've got an addendum saying buyer agrees to take over payments on the green space.
I've had them take over payments because it was on the seller's disclosure.
Sometimes they will, but and if you want to make that clear under the terms of the contract, just telling somebody that there's a special assessment out there is not necessarily their agreement to pay it. So I would, if you're going to have the buyer kind of take over that assessment, spell it out in the addendum.
Is that all of all points or is it just Andover Forest, Andover Hills?
Andover is the only one with the buyout, the big assessment.
That's $1,000.
They're like, well, it depends on the cost of the house. They were all.
And where
different.
it's like, they have like tiers, so we're in the highest tier because we're on a lake.
So yeah, some of the buyouts are bigger than others, and it just.
Cause I got
most of
the
them are paid
email
off.
that about the
So
1,000.
Yeah, most of the other HOAs won't have that. I've seen a discussion come up. We had a condo downtown that after the contract, the condo association levied a special assessment on the property. So in that situation, pursuant to the contract, that would be the seller's responsibility because it was levied on the property before closing. If a week later, after the buyer buys it, a special assessment gets announced by the condo association, that's on the buyer. Now, that would be a bummer, but that's the way it is. And if you want to get around that, you can, come up with a different agreement, that I don't know of any upcoming special assessments, that kind of thing.
Called a capital charge. Just so if anybody's listing a house, make sure you're aware of it. There's a capital charge now.
Yeah, some of those I think are a lot, they're like 3 something sometimes.
Yeah, and if you don't get the clear from all points in the beginning at $50. They charge you 200. I think it's 200 or something
Some
crazy.
of the-
So you gotta make sure that you do.
A lot of the
Yeah, right away.
associations, condo associations will especially charge those capital account or capital improvement assessments for every new buyer. Some of them are pretty high. I think Beaumont's got about $2,000 capital
Really?
contribution.
Wow.
How
There's-
much?
It's like $2,000. There's a certain set of the townhouses over there in Beaumont.
Oh, I did not know that.
It's a one-time
I'm just
fee
shocked
whenever
on
you
this.
buy
The
it.
buyer has to pay $1,000 no matter what.
Yeah. And that's something you might find in a seller's disclosure, but at that point, it's a for the buyer to do due diligence during the inspection period. And if after realizing that, they want to renegotiate,
Yeah, but I don't think a lot of agents even know anything about Andover. Like they don't know about that 10 years, financing the green space and stuff like that.
yeah, there are a few quirky ones. Pays to have a knowledgeable agent for sure.
Awesome.
All right, guys.
Well, thank you so much. I'm gonna thank Holbrook and Holbrook again, very incredible information and to our panel of Remax Realty agents. So yeah, definitely Holbrook and Holbrook is right downstairs on Remax Realty Hamburg. So I would definitely suggest after we have your closings and come up here and drop your checks off and
Make it easy with
It's so- it's so
Right.
easy now. I don't have to drive all the way over to
Yeah.
Wisconsin. I'm excited.
That's right.
Walk right
Are we
upstairs.
still recording?
Are we? I don't know.
all right, thank